In my previous video about international investment arbitration, I was suggesting that the United Nations Human Rights Committee might be used as a court of appeal after losing investment arbitration by an investor. Today, I would even suggest that it is a much more in-depth appeal court. It is an appeal court of much fuller jurisdiction than, for instance, the ad hoc committee within the ICSID system, within the ICSID mechanism. First of all, the United Nations Human Rights Committee would consider the case on discrimination in depth on merits. That does not exist before the ad hoc committee. Then the ad hoc committee would be limited to procedural rules. And the difference is that, first of all, well, let's take the recent case, Perenco. The ad hoc committee focuses on seriousness of procedural breaches. So the procedural breaches should be very serious in order to get the annulment of the award. It is much easier before the United Nations Human Rights Committee because there is no requirement of seriousness. They consider the breaches of procedural rights, but they do not have a requirement to prove that it was a serious breach. And then another thing is consideration of reasons. You know, the duty to state reasons. So if the arbitral tribunal states whatever reasons, the ad hoc committee will accept those reasons as valid. You know, they do not look into the reasons for, finding no discrimination. They just say that, there are reasons, whatever reasons, and that's enough. This is not an approach of the United Nations Human Rights Committee because that committee considers the reasons in depth. The next question is what happens if you win your case before the United Nations Human Rights Committee? What happens next? As a rule, the United Nations Human Rights Committee do not award damages, but they state that the damages should be, evaluated, assessed by national courts. In this case, there could be two scenarios. Either you go to the national courts, lose there or get too little damages, and then you go back to arbitral tribunal, or in a case where an arbitral tribunal may act as a court of the first instance, then you go directly to the arbitral tribunal in order to evaluate, in order to assess damages. This is something that was not tested, but theoretically it sounds reasonable to me. Subscribe to my channel.